Employment contracts. Introduction to the module. This module will teach you exactly what an employment contract is and its importance to the working conditions of an average employee. The UK laws around the contract are explored, and the different types of contract in job recruitment are fully explained. Topics to be covered in this module. Written statement. 2020's law regarding employment contracts. Type of contracts. Contents of lawful employment contracts. The risk of not giving a written employment contract on day one. Written statement. When the word contract is mentioned, the first image that comes to mind is a parchment scroll with Latin text that should be signed with a quill. But of course, things are far different from that in modern times. Strangely enough, there is no legal requirement that an employee should be handed a piece of paper that displays a written version of their employment contract. An employment contract comes into existence once an employee has formally agreed to take on a job. The actual contract is the agreement between employee and employer, not any kind of formally signed paper. But there is a legal necessity for an employer to give employees a document explaining the terms and conditions to which they are expected to operate. This document is not the actual employment contract, but it is proof of the terms of employment and what an employee is expected to do. The document itself is known officially by several names: written statement, particulars of employment, a written statement of employment particulars, a Section 1 statement, referring to Section 1 of the Employment Rights Act. While there are no strict instructions as to structure, a written statement must contain the following information: job title or description of the job, employer's name, employee's name, the date on which employment commences, number of hours of work and days expected to work, details of any overtime, details of the salary, holiday entitlement, the address or addresses of the workplace, details of procedures for grievance, dismissal and sickness, working abroad. Other information, such as pension schemes, also needs to be passed to the employee, but these can be included on other documents. This is likely to be an employee's handbook of some kind, which we'll cover in the next module. 2020's law regarding employment contracts. As we have seen in Module 1, UK employment law can be prone to many changes in modern times. So perhaps it is inevitable that there has been a very recent update. In fact, there have been significant changes applied to written statements that have taken effect from the 6th of April 2020. This is due to the introduction of employment rights, employment particulars and paid annual leave, Amendment, Regulations 2018, which supersedes the legislation contained in the previous law, Employment Rights Act 1996. The two main changes made are: written statements must be given to an employee on or before their first day at work. The time limit used to be within 2 months of starting work. Individuals defined as workers must also now be given written statements regarding any work agreements when it was previously just employees who had the legal right to receive one. As well as the information detailed in the earlier slide, from the 6th of April onwards, the written statement given to employees and workers must also contain the information which is given in the next slide. How many hours and the specific days of the week that worker or employee is expected to work. How likely the hours and days of employment are to be changed and when. The details of entitlements for workers and employees during scheduled paid leave. The details of benefits not covered elsewhere in the written statement. the details of any probationary period that the employee or worker is subject to, the details of any available training which the employer has made available to the workforce. This means that some information previously not mentioned on written statements now must be included by law. Type of contracts. Employment contracts will change according to the type of work and individual that is hired to do so. Along with the 3 types of employment status, employee, worker, and self-employed, there are also 6 distinct types of contract. The contract types are full-time, part-time, fixed term, 0 hours, agency, freelance or consultant or contractor. We shall summarize the differences and purpose of each one. Full-time. The most comprehensive of all the employment contracts. As well as including the written statement and all its contents, an employer must also provide full details regarding statutory sick pay, or SSP, minimum levels of paid holiday, payslip explanations, maximum or minimum amount of rest breaks, parental arrangements and benefits. As a part of this contract, an employer is also expected to deliver the following targets. Ensure that the employee does not work more than the recommended number of hours. Place liability insurance on the employee. Ensure that the employee gets more than the national minimum wage. Provide a safe work environment for all. Avoid any kind of discrimination. Install appropriate aids if the employee is disabled in any way. Ensure the employee is registered with the HMRC and pay taxes on their behalf. Part-time. This contract is designed to ensure that employees or workers who work part-time are still given job protection and benefits comparable to full-time workers. Although there is no exact definition, a part-time worker is usually accepted to be someone who works less than 35 hours a week. This may be due to personal circumstances or family responsibilities. The employer is expected to give the contract holder the same level of pay, holidays, pension, etc., although this will be in proportion to the hours worked. The contract also differs from full-time in these ways. Part-time workers or employees may not be eligible for overtime until they have worked over the normal hours of a full-time worker. An employer can treat a part-timer differently to a full-time worker with benefits if they can prove objective justification for doing so and is not due to unfair discrimination. A part-timer can request a written statement for their treatment if they think they have been poorly treated, and this must be presented by the employer within 21 days. Fixed term. This contract is designed to cover a specific task or job and will end on a given date or when that job is finished. It generally covers work like building projects or holiday cover. It does not include apprenticeships or work experience. 0 hour. This contract is sometimes known as a casual contract and is designed to cover intermittent work or for workers on call, such as health carers. Because of this, workers are only paid when they work and cannot demand employment. They are still allowed annual leave and minimum wage, however. Agency. This contract is the version usually utilised by temp agencies. It ensures that their workers get the same rights as full-time workers. After 12 weeks continuous employment in the same role, agency workers will get the same rights regarding the company's conditions on pay, number of working hours, rest breaks, shift work, holidays, facilities, internal job vacancies. As of the 6th of April 2020, the agency worker is also entitled to a key facts statement describing their work conditions. freelance or consultant or contractor. This contract is not beheld to the same legal restrictions as the previous ones. It covers the work performed by the self-employed and is therefore exempt from legislation regarding national minimum wage restrictions and such like. Content of a lawful employment contract. Bearing in mind what we have already covered regarding written statements and employment contracts, it is still useful to note all the major details that should be included within a lawful employment contract. In most cases, all this information will appear on a written statement or be available elsewhere. We shall include the changes made after the 6th of April 2020. The content should consist of name of employer, name of employee, the address of the main workplace, the job title or a job description, the date on which employment began, details of a previous job if it counts towards a period of continuous employment, the minimum number of hours to be worked, details of the salary, holiday entitlement, if fixed term, the date when the employment is expected to complete, the length of notice given for a dismissal, details of collective agreements or local benefits, details of the pension scheme, procedures around sick pay, disciplinary hearings, grievances and deductions of pay, details of working abroad or work travel, details of any probationary period, details of any available training. The very nature of an employment contract means that an employee may have grounds for complaint if any of that information is knowingly withheld from them, as we can see on the next slide. The risk of not giving a written employment contract on day one. As we have already noted, the legislation changes of the 6th of April 2020 mean that employers are now legally obliged to give a written statement on day one of employment, if not sooner. So, the risk of not giving a documented representation of an employment contract is now much more important than it used to be in a lawful sense. Before this date, the maximum time that an employee could be expected to wait for a written statement was 2 months from their start date. If the employee believes he has agreed to a rate of pay with an employer, he will have no proof of that until he receives the written statement or first payslip. If this is perceived to be incorrect, there could be a cause for grievance. If the matter is taken to an employment tribunal, it could well be that the judge finds in favour of the employee because the employer did not establish the rate sufficiently. A written statement removes all doubt of confusion regarding terms and conditions of an employment contract. Now legally required, this particular task should no longer be a concern. Summary. In this module, we have covered the following points. An employment contract is not the written statement received by an employee, but the actual agreement with the employer. Written statements must now be given to an employee by their first day of employment. There are 6 different types of employment contract. Essential information regarding a job role must be shared with an employee on the acceptance of an employment contract. Before recent changes in the law, an employer didn't need to give a written statement to an employee for up to 2 months.